Hello everyone, I would like to welcome you to this latest lecture on international legal instruments and protection of human rights as a part of the Swayam course on human rights, international humanitarian and refugee law. In this 15th lecture of the series, we will look into the structure of 7 key conventions for human rights protection. The international legal instruments for the protection of human rights are divided into 2 categories by the Office of the High Commissioner of Human Rights of the United Nations. The 2 categories are core instruments and universal instruments. The 9 core instruments of human rights protection are International Convention on the Elimination of All Forms of Racial Discrimination, International Covenant on Civil and Political Rights, International Covenant on Economic, Social and Cultural Rights, Convention on the Elimination of All Forms of Discrimination against Women, Convention against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, Convention on the Rights of the Child, International Convention on the Protection of the Rights of All Migrant Workers and Members of their Families, International Convention for the Protection of All Persons from Enforced Disappearances, and finally, the Convention on the Rights of Persons with Disabilities. 2 of the core instruments mentioned above, that is the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, are together called the international covenants. A third instrument called the Universal Declaration of Human Rights is also present and is studied together with the covenants. These 3 instruments together are called the International Bill of Human Rights. In the current lecture, we discuss the mode for human rights protection through 7 of the 9 core instruments of international human rights protection except the International Bill of Human Rights. All these 7 instruments have a specialized treaty monitoring body. The 3 instruments making up the International Bill of Human Rights will be discussed separately in another lecture. So, now we begin the discussion with the International Convention on the Elimination of All Forms of Racial Discrimination, commonly known as ICERD. The ICERD was adopted on 21 December 1965 and entered into force on 4 January 1969. As of March 2024, the ICERD has been acceded to or ratified by 182 state parties. The ICERD's scope and objective is to end all types of racial discrimination and to foster tolerance and understanding among various racial and ethnic groupings. Any differentiation, exclusion, limitation or preference based on race, color, descent or national or ethnic origin that has the intent or effect of undermining the acknowledgement, enjoyment or exercise of fundamental freedoms and human rights is classified as racial discrimination. Under the ICERD, state parties must take a number of actions to prevent racial discrimination, such as passing laws that forbid it, encouraging equality and the absence of discrimination in all spheres of public life, and opposing racist groups and propaganda. In addition, states must ensure that people of all races and ethnicities can enjoy their civil, political, economic, social and cultural rights without facing discrimination. To ensure that the state parties adhere to the treaty, the ICERD has created the Committee on the Elimination of Racial Discrimination or CERD, which is made up of impartial specialists. In order to address issues and encourage improved implementation of the ICERD, The committee may make suggestions and observations after reviewing periodic reports filed by state parties on their compliance with treaty obligations. The ICERD has a procedure for individual complaints that enables people or organizations to file complaints with the CERD. The use of this procedure is only possible if the state party against whom the individual complaint is sought to be made has accepted the process to receive complaints under Article 14 of the ICERD. Through this process, racial discrimination victims can seek justice and hold states responsible for their deeds or inactions. The second instrument which we discuss is the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW, which was adopted on 18 December 1979. It came into effect on September 3, 1981. As of March 2024, it has been ratified by 189 state parties. The goals and scope of CEDAW is to end all kinds of discrimination of women and advance their equal rights and opportunities in the social, political, economic and cultural domains as well as in the civil and political spheres of life. Discrimination against women is any kind of sex-based differentiation, exclusion or limitation that makes it harder for women to exercise their fundamental freedoms and human rights or to be recognized at all. State parties to the Convention on Elimination of All Forms of Discrimination Against Women must take a number of actions to end discrimination against women, such as passing laws that forbid discrimination, establishing programs and policies that advance gender equality, and getting rid of harmful stereotypes and discriminatory practices. States also have a duty to guarantee equitable access to jobs, healthcare, education and public life among other rights. To ensure that state parties adhere to the treaty, CEDAW creates a committee on the elimination of discrimination against women, which is made up of impartial specialists. In order to resolve issues and encourage improved CEDAW implementation, the committee evaluates periodic reports filed by state parties on their compliance with treaty requirements. It also has the authority to provide recommendations and observations. The optional protocol to CEDAW, which was adopted in 1999, offers an extra layer of oversight and enforcement. It enables people or organizations to file the complaints with the committee directly against state parties for violating their CEDAW rights. The committee may also look into systemic discriminatory practices against women in state parties thanks to the optional protocol. India is a party to the CEDAW since 1993, but not to the optional protocol. The third instrument which we will discuss now is the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, which was adopted on 10 December 1984 and came into force on 26 June 1987. As of March 2024, there are 174 state parties to the Convention Against Torture. The purpose of the Committee Against Torture is to stop torture and other cruel, inhuman or degrading treatment or punishment in all situations and settings. It describes torture as the purposeful infliction of severe pain or suffering, either mental or physical, on an individual with the aim of extracting information, punishing them or threatening them or a third party. Under the Convention on Torture, state parties should take all reasonable steps to prevent and suppress torture inside their borders. This entails passing laws against torture, looking into reports of torture as soon as possible and impartially, holding those responsible accountable, and offering rehabilitation and compensation to victims of torture. States also have a duty to make sure that no one is sent without their will back to a nation where they could be tortured. In order to keep an eye on how state parties are carrying with the treaty, the Convention Against Torture creates a Committee Against Torture, which is made up of impartial specialists. In order to resolve issues and encourage improved CAT implementation, the committee evaluates periodic reports that state parties submit on their compliance with treaty commitments. It also has the authority to make observations and suggestions. The Convention Against Torture establishes a system for individual complaints, enabling anyone to file complaints with the committee on the grounds that state parties have violated their rights under the treaty. Through this process, advocates of torture victims can demand reparations and hold nations responsible for their deeds or inactions. Convention Against Torture upholds the idea of universal jurisdiction, enabling state parties to bring charges against anybody suspected of torturing people, irrespective of the victims or offender's nationality or the location of the alleged crime. There is no statute of limitations for the crime of torture, and states are required to extradite or punish anybody who is suspected of torturing someone while on their soil. An optional protocol to the Convention Against Torture and other cruel, inhuman or degrading treatment or punishment was adopted in 2002, and it came into force on 22 June 2006. This protocol prescribes the creation of subcommittee on the prevention of torture and for establishments of national preventive mechanisms for prevention of torture. The fourth instrument that we discuss is the Convention of the Rights of the Child, also known as CRC, which was adopted by the United Nations General Assembly on November 20, 1989 and entered into force on September 2, 1990. As of March 2024, it has been ratified by 196 state parties, and India is also one of them and had acceded to the treaty in 1992. The CRC sets out the civil, political, economic, social and cultural rights of children under the age of 18. It recognizes the inherent dignity and worth of every child and aims to ensure that children enjoy special protection and care, as well as opportunities for the full and harmonious development of their personality. The CRC is guided by four core principles known as the 4 Ps: non-discrimination, best interest of the child, the right to life, survival and development, and the right to participation. These principles underpin the interpretation and implementation of all rights enshrined in the Convention. The CRC sets out a comprehensive framework of rights and obligations for state parties to promote and protect their rights of their children. These include the right to life, survival and development, the right to a name and nationality, the right to education, healthcare and social services, and protection from exploitation, abuse and neglect. The CRC establishes a committee on the rights of the child composed of independent experts to monitor the implementation of the treaty by state parties. The committee reviews periodic reports submitted by state parties on their compliance with the treaty obligations and may issue recommendations and observations to address concerns and promotes the implementation of the CRC. The CRC has 3 optional protocols that address specific issues related to children's rights. The optional protocol on the involvement of children in armed conflict, the optional protocol on the sale of children, child prostitution and child pornography, and the optional protocol on the rights of the child on a communications procedure. These protocols provide additional mechanisms for protecting and promoting children's rights in specific contexts. India has only ratified the first and second optional protocols and has not ratified the third optional protocol on the rights of the child on a communications procedure. The fifth instrument that we discuss is the International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families. It was adopted on December 18, 1990 and came into effect on July 1, 2003. As of March 2024, it has been ratified by 59 parties. India has not ratified this convention. The scope and objectives of the ICRMW are to safeguard the rights of migrant workers and their families, irrespective of their cause for movement or status as migrants. It aims to guarantee that migrant workers have the same rights and protections as citizens of the nations in which they work, acknowledging their susceptibility to exploitation, abuse and discrimination. The ICRMW lays out a thorough set of rights for migrant workers and their families, such as the right to freedom of movement and residency, the right to social security, employment and access to public services, the right to be treated equally with citizens in these areas, the right to be safe from exploitation, abuse and violence, and the right to access justice and effective remedies for the rights violation. The ICRMW guarantees that migrant workers and their families have the same rights to family life and reunification as citizens of the host nation, acknowledging the value of maintaining family unity. States parties must support the reunion of families and defend the rights of migrant workers to stay in touch of their relatives. To oversee the treaty's implementation by state parties, the ICRMW has created a committee on the protection of the rights of all migrant workers and members of their families, which is made up of impartial specialists. In order to address issues and encourage improved implementation of the ICRMW, the committee may provide recommendations and observations after reviewing periodic reports presented by state parties on their compliance with treaty obligations. The sixth convention we discuss is the International Convention for the Protection of All Persons from Enforced Disappearance, which was adopted by the UN General Assembly on December 20, 2006 and entered into force on December 23, 2010. As of March 2024, 72 states have ratified the convention. While India signed the convention in 2007, it has not yet ratified it. The ICPPED's scope and objectives include preventing and opposing enforced disappearances, protecting victims and their families' rights to justice and the truth, and offering victims compensations and remedies. It forbids forced disappearance under any conditions and acknowledges it as a serious violation of human rights and a criminal offence under international law. According to the ICPPD, an enforced disappearance occurs when a person is arrested, detained, abducted or subjected to any other form of liberty deprivation by state agents or with their consent, and then they refuse to acknowledge the deprivation of liberty or to reveal the whereabouts or fate of the disappeared person. Both individual and groups disappearances are covered. State parties to the ICPPD must take decisive action to stop enforced disappearances, look into claims of enforced disappearances as soon as possible and objectively prosecute offenders and offer victims' relatives remedies and compensation. States must also create legal frameworks to fight impunity and prohibit forced disappearances. To oversee the treaty's implementation by state parties, the ICPPD forms the Committee on Enforced Disappearance, which is made up of impartial specialists. In order to resolve issues and encourage improved implementation of the ICPPD, the committee may provide suggestions and observations after reviewing periodic reports filed by state parties on their compliance with the treaty. The ICPPD has a procedure for individual complaints that enables people or organizations to file complaints with the Committee on Enforced Disappearances accusing state parties of violating their rights under the treaty. Through this method, relatives of those who were pushed into disappearances can seek compensation and hold states responsible for their deeds or inaction. The seventh and final convention that we discuss is the United Nations General Assembly, which enacted the Convention on the Rights of Persons with Disability, which was officially adopted by the UN General Assembly on December 11, 2006 and entered into force on May 3, 2008. As of March 2024, 191 state parties have ratified the convention. The CRPD aims to guarantee the full and equal involvement of all people with disabilities in all facets of life by acknowledging their entitlement to the same fundamental freedoms and human rights as everyone else. It takes a human rights based perspective on disability, highlighting the worth, freedom and dignity of people with impairments. The Convention on the Rights of the Person with Disabilities is based on a number of fundamental ideas, including the following: equality of opportunity, full and effective participation and the inclusion in society, non-discrimination and respect for difference and acceptance of people with the disabilities as members of the human race. The Convention on Rights and Disability delineates an all-encompassing structure of entitlements for those with impairments, encompassing civil, political, economic, social and cultural rights. These rights encompass a variety of areas such as the freedom from discrimination and inequality, the right to accessibility, the freedom to live freely and participate in society, the right to health and education, the right to work and employment and the right to access justice. It is mandatory for state parties to implement measures aimed at guaranteeing the fulfillment of these rights and removing impediments that hinder individuals with disabilities from enjoying their rights on an equal footing with others. Under the CRPD, states parties are required to designate a committee on the rights of persons with disabilities made up of impartial specialists to oversee the implementation of the treaty. In order to address concerns and encourage greater implementation of the CRPD, the committee may make suggestions and observations after reviewing periodic reports filed by state parties on their compliance with treaty commitments. An optional protocol to the CRPD was adopted in December 2006. An extra monitoring and enforcement mechanism is provided by the CRPD's optional protocol. It enables people or organizations to file complaints with the Committee on the Rights of Persons with Disabilities, accusing signatory governments of violating the rights guaranteed to them by the treaty. Through this method, people with disabilities and their advocates can hold governments responsible for their actions or inactions and seek remedy. India is not a party to the optional protocol. The 7 conventions mentioned here, along with the 3 documents making up the International Bill of Human Rights, form the backbone of the human rights enforcement framework in international law. The large number of ratifications to these conventions indicates global support and acceptance of the idea and the need to protect human rights across different domains for people across the world. Thank you.